So small technical issue. So in this lecture, I'll revise two chapters. Chapter 2, incorporation of company, matters incidental thereto. And the second one is foreign company. Both had a decent weightage of 5 marks. So you can expect 10 marks from this marathon lecture. Clear? So starting with incorporation of company and matters incidental thereto. In this chapter, we are having total 20 sections. Section 3 to section 22, and one important definition, that is promoter. First we will see the promoter. So who is a promoter? A person may be natural person, may be artificial person. Yes, promoter can be either natural person or artificial person. For subsidiary company, holding company is the promoter. Clear? So a person who is named as a promoter in the company prospectus or identified in the annual return. That means named promoter. And second one who exercises control over company affairs directly or indirectly as a shareholder, director or otherwise. So second one is one who is having control over affairs of the company as a director or a member or otherwise. Maybe creditor also. Creditor is also a promoter. If he is a major financier. Clear? Next one who provides advices, directions or instructions that the board of directors is accustomed to follow. That is AID. Advices, instructions, directions, board of directors are following them. But to this last point, if you see, there is one exception. That exception is person acting solely in the professional capacity. That is solicitor, banker, accountant. So these people are not treated as promoter, but remember, as long as these people are providing services in the professional capacity, they won't be treated as promoter. If they render services beyond the professional capacity, then they will be treated as promoters. Getting my point? So this one exclusion is there, that is with respect to C point only. For C point there is one exemption. Clear? Again I am telling you, promoter can be either a natural person or artificial person, and a company can have more than one promoter. So based on this point, we will see one exceptional question. XYZ Infra Projects Limited was incorporated on 10th June 2021 for the purpose of developing a residential township in the Hyderabad. The initial subscribers to the memorandum were Ramesh, Kavita, Anil, who later became first directors of the company. In financial year 23-24, company faced severe liquidity issues. At this stage, Suresh, a real estate investor, was not a shareholder, was not a director of the company. However, he actively participated in the negotiations with the banks, introduced private investors, arranged bridge finance of 15 crores, and regularly advised the board on fundraising strategies. The board of directors was accustomed to act on his advice. Now tell me whether Suresh is a promoter or not a promoter. If you see the third point in the promoter definition, on whose advices, instructions, directions board of directors are accustomed to follow, then that fellow also becomes promoter. In April 2024, company issued a prospectus to raise 40 crores from the public. The prospectus contained an overstatement of project approvals, which later turned out to be misleading. That means misstatement. So this question is a combination of incorporation of company and the prospectus. The prospectus named only Mr. Ramesh as promoter. However, annual return for the financial year 23-24 identified both Ramesh and Suresh as promoters. You tell me whether Suresh is there since incorporation of the company, or did he came in the middle? He came in the middle. He didn't came at the time of incorporation. He was not there since incorporation. Mr. Suresh contended that he was not a promoter as he was neither associated with the incorporation of the company nor formally appointed as a director. Hence, he should not be held liable for the misstatements in the prospectus. So, whether Suresh can be regarded as a promoter under the Companies Act 2013? Answer me. So, students, just reply me in the live chat. So, whether Suresh can be regarded as a promoter under the Companies Act 2013? Yes. On what grounds? On the grounds of AID, advisors, instructions, directions, board of directors accustomed to follow. Whether it is mandatory that a promoter must be associated with initial formation of the company? Not required. Not at all required. Even after incorporation, subsequently, if you are becoming a controlling shareholder, if you are becoming a managing director of the company, one who control affairs of the company, you will become a promoter. So need not be required since incorporation. Whether Mr. Suresh can be held liable for misstatement in the prospectus despite not being named as a promoter therein? Yes, liable, because annual return named him as a promoter. Moreover, AID, advisors, instructions, directions, based on that point, he is already a promoter of the company. Would your answer change if Suresh acted only as a chartered accountant advising the board? So if he is a professional rendering services in the professional capacity, our answer will definitely change. So from this D point of view, don't apply this one. Don't apply this point. Don't get confused. Don't apply this point. So accordingly, our answer will change. Answer would change. Clear? Second question. This is about one-person company. Let's see. Concept book. Minimum number of members, you all know. Minimum public company 7, maximum 200. Private company minimum 2. Sorry, public company minimum 7, maximum unlimited. Private company minimum 2, maximum 200. OPC minimum 1, maximum 1. This is with respect to number of members. With respect to directors also we will see. Public company minimum directors is 3. Private company minimum directors 2. OPC minimum director 1. And what is the maximum number of directors in each company? In each company, maximum number of directors is 15. Don't get confused with OPC. OPC minimum and maximum 1 is per member. Minimum and maximum 1 is per members. But coming to the directors, minimum 1, maximum 15. Clear? Next one, section 3A. Many students are confusing about this point, section 3A. See, what is section 3A? What is section 3A? See, company was incorporated, for example, in the year 2020. It is doing business. This company is ABC Limited, public limited company, where 7 subscribers are there. A, B, C, D, E, F, G. EFG, they are doing business. One is doing business in France, other one is doing business in Germany, and all A, B, C, D, E, 5 members are in India. Now what happened is, one day, for example, 1st January 2025, Mr. D and Mr. E died in an accident. Now exactly on 1st January 2025, what happened? Number of members from 7 fallen to 5. So law is giving a time limit of 6 months to increase the number of members. So 6 months means simply from 1st January 2025 to 6 months, 30th June 2025. By 30th June 2025, this 5 should be increased to 7, or else what happens? The debts that were contracted by the company, the obligations, the contracts entered into by the company after 6 months from the date of reduction of number of members, for all those debts, company is not liable. Company is not liable. Who is liable? Members who are aware of the fact that company is doing business with a reduced number of members. For example, FNG, they are in outside India, they don't know about the reduction of number of members. ABC know about the reduction of number of members. So that means ABC, they are jointly and severally liable, and their nature of liability is unlimited. There is no limit on their liability. For which debts? For which debts? Debts contracted during the 6 months or debts contracted after 6 months? Debts contracted after 6 months from the date of reduction of number of members. So that means company separate legal entity character will be there till the expiry of 6 months. After that, there will be no separate legal entity concept. There will be no limited liability concept. Getting my point? So debts contracted after expiry of 6 months from the date of reduction, members liability will be unlimited. Whose members liability? Members who are cognizant of the fact, that means who are aware of the fact that business is carried with the reduced members. Such members shall be sued severally and entire debt incurred during that time. Clear? Next one. Procedure for incorporation of company. This is a normal question only. So here a list of documents to be prepared. I will tell you. First, MOA, AOA, signed by all the subscribers. So that means signed MOA, signed AOA. Declaration by the professional, and declaration by the person who is engaged in the incorporation of the company, that is director or manager or secretary, confirming compliance. That means proposed company's incorporation is as per Companies Act 2013 and rules made thereunder. And declaration by all the subscribers that they have paid value of the shares agreed upon. Verification of registered office has been filed. This shall be done before commencement of the business. See, this declaration should be filed after incorporation but before commencement of the business. not at the time of incorporation, not at the time of incorporation, post incorporation, but before commencement of the business. Declaration by each subscriber and a first director stating that they are not convicted of any offense relating to the promotion management of the company, not guilty of fraud, misfeasance, breach of trust in the last 5 years. So 5 years disqualification in case you have committed an offense, in case you are convicted of any offense in the promotion management of the company, or if you have been found guilty of fraud, misfeasance, 5 years disqualification to you. That means after 5 years you are eligible to become a subscriber, you are eligible to become a director of the company, and all the documents filed with ROC contain correct and complete true information to the best of their knowledge and belief. Next one, address for correspondence till registered office is established. So this is temporary address. And details of the subscribers. What comes in details of the subscribers? Name, photograph, parents name, nationality, place of birth, educational qualification, PAN, proof of identity, residential proof. If subscriber is already a director or promoter of the company, they shall provide details such as company name, SIN, and their role as a director or the promoter. So interest of the directors in the other body corporates. If a body corporate subscribes to the MOA, then these details shall be furnished. And coming to the details of the first directors, same name, DIN, nationality, residential address, proof of identity, consent to act as a director shall be filed. Next one, declaration required if you are a Nidhi company or if you are doing an activities which are regulated by RBI, SEBI, then from RBI and SEBI approvals to be taken. Those things are also to be filed with ROC. Finally, ROC will issue certificate of incorporation. In that certificate of incorporation, along with SIN, you can also find PAN, you can also find TAN. TAN is for making TDS, PAN is for filing income tax returns. SIN, that is identity number of the company, unique identity number. So yes, from the date of incorporation, ROC allots a SIN, it's a distinct identity. Maintenance of the documents, remember all the documents so far we have seen, all these documents shall be preserved till the liquidation of the company at the registered office. Chance is there, MCQ may come, till the liquidation of company at the registered office. Next one, signing of MOA, May 25 attempt, 5 marks question came on this. Generally signing means manual signing, but now all the forms are filing, all the forms that we are filing with ROC are electronic forms, so digital signature is compulsory. But previously, before digital signature, how signing of MOA has been done, you can see here. So illiterate subscriber will affix thumb impression, but a literate person should read the content and should explain the content to that illiterate subscriber, and that literate person should also add his name, should also sign along with this thumb impression of the illiterate subscriber. Typewritten printed details, yes, accompanied by the signature or thumb impression. Body corporate, authorized person, that authorized director, how gets authorized, how authority comes? Through board resolution. LLP as a subscriber, how authority comes? With the consent of all the partners, with the consent of all the partners. You can see authorized partner. So in case of body corporate or LLP, authorized person cannot act as a subscriber to the MOA and AOA simultaneously, because there should be no conflict of interest. There should be no conflict of interest. Represent body corporate, that's it. So again I'm telling you how authority comes: only with the consent of the partners, with the consent of partners or with the consent of the directors. So board resolution in case of company, power of attorney in case of LLP. Foreign national as subscriber, here authentication of documents is important. So if you are residing outside India and your signature, address, identity proof must be notarized by a notary public with a certificate. If the country is not part of Hague Apostille Convention, the certificate shall be authenticated by a diplomatic or consular officer, simply embassy. If you are residing in India, non-resident only, residing in India, that means you visited India with a valid business visa. So show that valid business visa, enough. If you attach business visa, that is enough. Business visa is not applicable to the persons of Indian origin or overseas citizen of India. And next one, this point, consequences of furnishing false information, dangerous point. So during incorporation stage, if you furnish any false information, like forgery of identity, forgery of the document proofs, in case of forgery of these documents, yes, this particular section will come into the picture, this particular punishment will come into the picture. That is, if any person provides false or incorrect information, suppress material facts knowingly during the incorporation process in the documents filed with ROC, they shall be liable for the fraud under section 447. So here, company was not yet incorporated, company was not yet registered. But second point, company already registered, sir. Then the persons associated with incorporation, they gets punishment under section 447. Simply promoters, first directors, and professional also. Professional also. If professional is also committing an offense without verification of the documents, if he is giving declaration, yes, everything is as per Companies Act only, subscriber documents are perfect only. So like that, if professional is doing a mistake, he will also get the same punishment. But along with the individuals, company will also get punishment. Sir, what punishment company will get? Tribunal may pass orders such as alter MOA AOA, convert members limited liability as unlimited liability, that means lifting of corporate will, remove company's name from the register, order for winding up, issue any other orders as deemed necessary. But before passing any of these orders, company will be given an opportunity of being heard, and tribunal shall also review the company transactions including obligations and liabilities before making an order. So this is about pre-incorporation procedure. And post-incorporation, if it was found that company was incorporated by furnishing false information. In one attempt, this particular third point was tested for 5 marks. Direct theory question. Next, coming to OPC, very simple. Remember, in OPC, 3 things you remember. 3 things. One is about member. The second one is about nominee. The third one is about company. So simply to save the status of perpetual succession for company, along with member, appointment of nominee is required. Simply to save company from perpetual, if something happens to the member, so what about the company? Who will take care of company affairs? So looking at the reasons, in case of OPC, additional person, you will see that additional person is nominee. Okay, so both member and nominee should satisfy 2 conditions. One is Indian citizen, second one is natural person. Before amendment, we had a third condition, that is Indian resident, but now this condition is not there. Only 2 conditions to be satisfied. First of all, he or she should be a natural person. Of course, he, she, natural person only. Next one, citizen of India. Next, coming to the company. Company can do any activity except 3 activities. One is NBFC activities, second one is Section 8 activities, and third one is investment in body corporate activities. Investment activities not allowed. These 3 activities not allowed in OPC. I am telling you, these 3 are not illegal activities, but for OPC not permitted. Remember this point. In section 6 I will use the same point. We'll see the material. So only a natural person, Indian citizen, whether resident in India or not, can incorporate OPC, be a nominee. Resident in India for this purpose, for this section purpose. Resident means not what you read in Income Tax Act or what you read in FEMA Act. Here resident in India means at least 120 days in the preceding financial year. Next one, maximum a person can become a member or nominee in only one OPC. But if a person becomes member of another OPC, he shall resolve this conflict within 180 days. See, I'm a member in one company, nominee in another company. In another company, that member died. Now I'll become member in that another OPC. So here I'm simultaneously holding membership in 2 OPCs. So corrective action to be taken within 180 days of becoming member in second OPC. Minors cannot become members, nominees, including they cannot hold beneficial interest also. OPC cannot be converted into Section 8 company. OPC cannot engage in NBFC activities, and OPC cannot carry investment activities. Next one, nominee must be named in MOA, but before naming someone as nominee, consent shall be obtained in writing. Written consent shall be obtained and filed with the ROC. From whom? From the nominee. And this nominee can withdraw his consent at any point of time, or sole member may remove the nominee. Removal of nominee, resignation by the nominee, nominee becoming member. 3 cases are there. So if in all these 3 cases nominee position becomes vacant, in that case what we have to do? Within 15 days appoint a new nominee, and within 30 days communicate the same with ROC. So the company shall file a notice of change in nominee within 30 days of nominee becoming member. Withdrawal of nominee, that is nothing but resignation by the nominee. Replacing nominee, that is nothing but removing nominee. So submit INC 4 within 30 days of event. Benefits of OPC. no cash flow statement required. Annual returns, it's enough. One director signing annual return. One board meeting for half year is enough. OPCs can file financial statements within 180 days from the end of the financial year, because normal companies within 1 month from the completion of AGM, within 1 month of AGM financial statement should be filed. But for OPC, AGMs is not required. AGM is not required. That's why financial statement should be filed within 180 days from the end of the financial year, and change in nominee shall not be deemed to be an alteration of MOA. So this is also advantage only. And remember, based on this last point also a question may be framed. So there is a change in nominee. Member is arguing that change of nominee requires amendment of MOA. So tell me, amendment of MOA required for change of nominee? Answer is no. So based on this, we will see exceptional questions. Mr. Arjun Mehta, aged 32, an Indian citizen, is a software consultant. Okay. During financial year 24-25, he stayed in India just for 95 days and remaining period abroad. On 5th April 2025, he proposed to incorporate a OPC named Ms. Arjun Tech Solutions OPC Private Limited with an authorized capital of 10 lakhs and paid up capital of 5 lakhs. So in the preceding financial year, that is 24-25, his period of stay is just 95 days, which is less than 120. So can he incorporate OPC in India? Array, for incorporating OPC in India, residential status is not a matter. Only two conditions: natural person, Indian citizen. Clear? While filing Form INC 32, Mr. Arjun nominated his friend Mr. Rohit Sharma, an Indian citizen residing in India, as a nominee. Indian citizen, enough. Citizen residing in India, enough. Obtained his consent in Form INC 4. The MOA, AOA duly filed with ROC along with the prescribed fees. Separately, Mr. Rohit Sharma was already sole member of another OPC, Rohit Innovations OPC Private Limited, which was incorporated on 1st January 2024. And many students had a wrong perception. Who can be nominee? Only family member or other than family member? And the answer is any person can become a nominee. Need not be a family member. Need not be a family member. On 20th August 2025, due to sudden death of Mr. Arjun, Mr. Rohit became member of Arjun Tech Solutions OPC Private Limited by virtue of being nominee. That means, with effect from 20th August 2025, Mr. Rohit became member in two one-person companies. One is his own OPC, other one is Arjun Tech Solutions OPC. Okay. The statutory auditor later raised a query regarding eligibility, validity of incorporation and compliance timelines under OPC provisions. So whether Mr. Arjun Mehta was eligible to incorporate an OPC despite staying in India for only 95 days in financial year 24-25? Yes. Residential status is not a matter, whether resident in India or otherwise. Next one, whether nomination of Mr. Rohit Sharma is valid? Yes. Prior written consent is required. Getting it? So not a minor, valid only. After becoming member of two OPCs, what compliance requirement Mr. Rohit should fulfill, and within what time? Within 180 days he should fulfill one compliance. What is that compliance? He should exit from one OPC. So Mr. Rohit must cease to be member of one OPC within 180 days, as a person can be member of only one OPC at a time. So 20th August, right? 20th August he become a member of another OPC. So from this to this add 180 days. You will get a day. By that day, action to be appropriate action for complaints to be taken. Next, question 3 is all about incorporation of the company. This one also I completed. Let's see. Greenfield Agritech Private Limited was incorporated on 12th April 2023 with an authorized share capital of 50 lakhs. The first subscribers and directors were Mr. Kunal Verma and Ms. Ritu Verma, who also acted as a promoters. During incorporation, declaration was filed stating that company would carry on agriculture consulting services only. Agri consultancy services. In August 2024, during an inspection by the registrar of companies, it was discovered at the time of incorporation, the promoters had suppressed material facts regarding prior convictions of Kunal Verma in a financial fraud case. Further, certain declarations and affidavits filed along with the spice forms contained incorrect particulars related to the past business activities. The company had already entered into several contracts with suppliers and borrowed 1.2 crore from banks by March 25. On receiving the inspection report, an application was made before NCLT seeking appropriate action against the company and its promoters for fraudulent action. Promoters argued that since company was already incorporated and functioning, no severe action should be taken and at most monetary penalties should be imposed. So what is the argument of the promoters? Company already incorporated, no? We got certificate of incorporation. So all the prior activities simply null and void. Now onwards would be valid, like that, that is the argument of the promoters. So whether furnishing false or incorrect information at the time of incorporation attracts liability under Companies Act 2013? Yes. What is the liability? Section 447. Who can be held liable where a company is found to be incorporated by suppressing material facts? All the persons associated with the incorporation, first directors of the company, promoters, even professional also, you can see promoter, first directors, and person making declarations are liable for fraud. And what orders can the tribunal pass in such a case? The tribunal may regulate management of the company, change of management, change of MOA, alteration of members liability limited to unlimited, removal of the name, and winding up of the company, or such other orders as it deems fit. But before passing any order, what tribunal will do? It will give an opportunity of being heard. And second thing, it will review the activities or transactions entered into by the company. You can see here 1.2 crore loan from banks, right? So it will review tribunal will review all the past transactions, and after giving one reasonable opportunity of being heard, tribunal will pass an appropriate order. So next one is about Section 8 company conversion into other kind of company. So far not tested, we'll see that point. See, Section 8 companies, only important point is what are the conditions a Section 8 company should satisfy. Conditions Section 8 company should satisfy. First one, object clause. Object should be commerce, arts, science, sports, education, research, social welfare, religion, charity, protection of the environment. And next one, what about surplus? Treatment to the surplus. Intends to apply its surplus or other income in promoting the objects. Then what about dividends? Allowed or not allowed? Strictly prohibited. Prohibit dividend payment to the members. And next one, so this is a normal company getting converted into Section 8 company, or at the time of incorporation only getting a Section 8 company recognition. So apply in Form Spice Plus with required fees. Also file MOA 3-year financial projections. Declaration by a professional stating that MOA complied with Section 8 and all legal requirements for company registration under Section 8 have been met. Coming to the privileges, it had the same privileges like other companies. That means separate legal entity, limited liability, perpetual succession, everything. Apart from these privileges, general meeting can be called by giving just 14 days notice, and this company is exempted from the compliance of directors requirements. No need to constitute NRC, Nomination Remuneration Committee. Even a partnership firm can become member of Section 8 company. Members liability is limited, and the words limited or private limited not to be added, not required. Exempted. Section 8 companies are exempted from using the words limited or private limited in its name clause. Next one, alteration of MOA, AOA. This is important point, in one attempt, I think in one MTP, I have seen this point, one MCQ, 2 marks MCQ. So alteration of MOA, AOA as per Act requires permission of CG. But as per rules, powers already delegated to regional directors as well as ROC. See, RD approval is required for alteration of MOA. Observe carefully. For alteration of MOA, RD approval is required. And for alteration of AOA, ROC approval. Don't get confused. And don't think RD approval is for both MOA, AOA. MOA, RD approval. AOA, ROC approval. Clear? AOA requires ROC approval. AOA alteration requires ROC approval. MOA alteration requires RD approval. Next one, conversion of Section 8 company into other kind of company. So 2 times special resolution to be passed. One time for filing application with government, central government. Another time for alteration of MOA and AOA. So pass special resolution for approving such conversion. Explanatory statement should contain the details of such conversion, and file INC 18 with a regional director. Along with that, pay prescribed fees. Also serve documents by registered post or by hand delivery to the income tax officer, chief income tax officer, assessing officer, charity commissioner, any department of CGSG having company's jurisdiction, chief secretary of the state where registered office is situated, so that grants, donations, everything, whatever status company is enjoying, all those benefits will be cancelled, including tax benefits will also be cancelled. If any authority wants to make a representation to the RD, it shall do within 60 days of receiving the notice after giving company an opportunity to respond. So 60 days time period is there for raising your objections. Publish a notice in 2 newspapers, vernacular newspaper, English newspaper. Also place it on company's website and CG notified website before 1 week of filing, within 1 week of filing an application. Compliance: file all financial statements and returns up to the preceding financial year, or else your application will be rejected. So if application is made 3 months after preceding financial year, attach financial position statement which should not be older than 30 days, certified by a CA. You know, the meaning of this point is recent closure of financial year is 31st March 2025. If you are filing application within 3 months, if you are filing an application, no problem. But if you are filing application after 3 months, now for this period also you prepare a new financial statements, you know, periodical financial statements which should not be older than 30 days. So simply here I am writing periodical financial results not older than 30 days, not older than 30 days. If you are filing application within 3 months of completion of financial year, no need to add new financial statements for that 3 months period. But if it is more than 3 months, the gap between closure of financial year and filing of application, if it is more than 3 months, for this period also prepare periodical financial results which should not be older than 30 days. Regional director's role: if RD is satisfied, conversion subject to if RD is satisfied, approves conversion. Before imposing conditions or rejecting the application, RD gives reasonable opportunity of being heard to the company. So post approval actions: again convene a general meeting, pass special resolution. So 2 times here, 1 SR for application, another SR for alteration of MOA AOA. Why? Because so far your object clause had, you know, charitable objectives. Now profit oriented objectives incorporate. File updated documents with ROC for fresh certificate of incorporation. On this we will see exceptional questions. Sankalp Skill Development Foundation, a company registered under Section 8 of Companies Act 2013, was incorporated on 1st April 2020 with the object of promoting occasional training for rural youth education or skill development. The company has received grants and donations aggregating 4.8 crore up to 31st March 2025. Its registered office is situated in Pune, Maharashtra. In May 25, due to strategic shift and reduction in charitable activities, the board decided to convert the company into private limited company to undertake commercial training programs and distribute profits. Accordingly, general meeting was held on 10th June 2025 and a special resolution was passed approving the conversion. The notice of meeting containing explanatory statement specifying the reasons for conversion. On 20th June 2025, company filed an application in Form INC 18 with regional director along with the prescribed fees. Next, company also intimated the ROC through the MCA system. Okay. However, company failed to publish the public notice in Form INC 19 in 2 newspapers and also had pending annual returns for the financial year 23-24. Despite this, company requested regional director to approve the conversion urgently. Allowed or not allowed? Come on, respond. Respond. Allowed or not allowed? Pending compliance. Is company allowed to convert itself into other kind of companies? Just now I shown you the point here. File all the pending financial statements and returns up to the preceding financial year. So conversion allowed or not allowed? Answer is not allowed. So whether passing of special resolution mandatory for conversion into other kind of company? Yes. Whether non-publication of notice in Form INC 19 affects the validity of the application? Yes. Failure to furnish public notice in Form INC 19 makes application non-compliant. Whether regional director can approve conversion when annual returns are pending? No. Regional director had no power, no authority to approve the application. So company must file all the pending financial statements and annual returns up to the preceding financial year before applying. State the procedure to be followed after approval of conversion by the regional director. Once again, convene a general meeting. Ask members to pass special resolution in order to amend MOA, in order to amend AOA. File them with the ROC, after which a fresh certificate of incorporation is issued. So next one, revocation of license to the Section 8 company. Many times this concept was tested in the examination. Simple concept only. If company violates the conditions of the license, if company affairs are conducted fraudulently, if company objects are violated prejudicial to the public interest, then upon revocation, ROC shall add limited or private limited to the company name in the register. That means mandatory conversion. This is not voluntary conversion. This is compulsory conversion of Section 8 company into other company. Before revocation, company shall be given written notice and an opportunity to be heard. And after revocation of the license, if it serves the public interest, CG may order the company to be wound up or to be amalgamated with the another Section 8 company with similar objectives. Observe carefully. Amalgamation with Section 8 company not enough. Section 8 company which is having objectives which are similar to the present Section 8 company. So objectives of this company, whose license has been revoked, and the proposed company, both objectives should be matching. That's what similar objectives. CG provides guidelines for winding up or amalgamation. CG is having complete authority to approve and structure the amalgamation, determining new entity's constitution, assets, powers, rights, obligations. Post wind up, surplus amounts left over will be credited to IBF or similar Section 8 company. Sir, similar Section 8 company means what? Section 8 company with similar objects. Next one, penalty or punishment. Default in complying with Section 8 requirements, company fine 10 lakhs to 1 crore. Directors in default, fine 25,000 to 25 lakhs. And for fraud, Section 447. Example, black money. To convert black money into white money, I registered a Section 8 company. In the name of fictitious persons, I'm crediting some amounts to my Section 8 company. So who are the donors? Are they really in existence? No. Fraudsters, fictitious persons. Simply in the name of fictitious people, if I'm making donation, trying to convert black money into white money, that's it. That is a fraud, and the punishment would be 447. Effect of registration, simple ma. Just remember the characteristics of the company. Write the characteristics of the company. Post incorporation, acquire, hold, dispose of the property, enter into the contracts, can sue, can be sued. Next one, MOA and its significance. In this MOA, the most important clause is object clause, the two doctrine of ultra vires. Clear? So a company cannot act beyond the power stated in the MOA. Such actions are void and considered ultra vires the company. So doctrine of ultra vires point, let me highlight here. Doctrine of ultra vires. See, any act not stated in the memorandum is considered ultra vires. No party, including an outsider, can sue for the validity or enforcement of such an act or such an agreement, ultra vires agreement. Ultra vires acts generally incapable of ratification because only valid acts can be ratified. Void acts can never be ratified. Void from the beginning. Void ab initio acts can't be ratified. If the act is intra vires company but beyond the authority of the directors, then company may ratify in the proper form. If act is ultra vires the directors' powers, shareholders may ratify it. If the act is ultra vires the AOA, company can alter the AOA. But ultra vires as to the MOA cannot be ratified. Ultra vires as to AOA can be ratified at the general meeting. The doctrine protects shareholders and creditors by ensuring company acts only within the defined objects. And we had a famous case study also, Ashbury Railway Carriage Company versus Ritchie. So let's see the question on this point. Iron Build Engineering Limited was incorporated on 1st April 2022 as a public company. The object clause of its memorandum of association stated that company was formed to manufacture, sell, hire, lease equipment and to carry on the business of mechanical engineers and general contractors. In July 2024, the board of directors entered into a contract with Euro Rail Consortium, a foreign firm, to finance the construction of railway project in Spain for a consideration of 120 crore project. The project had no direct connection with manufacturing or supply engineering equipment. So this is finance project. This is a finance contract. At the general meeting held on 15th August 2024, a contract was ratified by the shareholders holding 92% voting power. Subsequently, due to financial stress, Iron Build Engineering Limited cancelled the contract, claiming it to be ultra vires the memorandum. So already 92% voting power members ratified it, more than special resolution. Euro Rail Consortium filed a suit for damages for the breach of contract, contending that the words general contractors in the object clause empowered the company to enter into such contracts, and further argued that the act has been already ratified by the members. Meanwhile, Minority shareholders approached court seeking an injunction to restrain company from proceeding further with the contract. So let's answer the following questions. Whether contract entered by the company is ultra vires? Yes. Whether shareholders can ratify an ultra vires contract by passing a resolution? No. Ultra vires as to the MOA cannot be ratified. Ultra vires as to AOA can be ratified. So answer is no. Whether Euro Rail Consortium can sue company for damages or enforcement of the contract? Answer is no, because this is a void ab initio agreement. Whether a member of the company can seek an injunction in this case? Yes. Even a single shareholder can also take an action against the company. So need not to possess 10%, 20%, 25% of the capital. Even if you are holding one share, you can bring injunction order stopping the company from entering into or from continuing the ultra vires acts. Exceptional question. Next exceptional question. Yes, this is about liability clause of the company. We will see that point also. So yes, MOA object clause is important. Name clause name clause. So what can be the name of the company? Any name, or the name shall not be identical or similar to the existing company. So the name shall not be identical or similar to the existing company. The name shall not be undesirable in the opinion of central government. Sir, undesirable means what? Undesirable means CG or SG believes that the company is having some connection with CG or SG or local authorities. If government thinks that allowing this name creates an impression among the public that this company is associated with the government or local authorities, and this kind of names require prior CG approval, like board, authority, national, president, SSI require prior CG approval. And special entity names like insurance, if you want to use insurance word, IRDA permission. Banking name requires RBI permission. Stock exchange name requires permission of SEBI, and MCA, etc. Permissions are to be taken. And resemble rules name shall not be plural or singular form of existing company names. And even a type of the letters, spacing between the letters, punctuation marks, use of different tenses, slight variation in the spelling, phonetic spellings, complete translation or transliteration, use of host name, order of the words, changing order of the words, using the article definite or indefinite. Example, Reliance Industry is already there, right? So the Reliance Industry Limited, there is nothing but article. Addition of the name of a place to an existing company, addition, deletion, modification of numerals, unless that numeral represent brand. For example, OnePlus, you take OnePlus mobiles, so that numeral is a brand. That number 1 is a brand, so that is allowed, but others are not allowed. So Reliance One Industries Limited, allowed or not allowed? Or not allowed. Next one, reservation of name. So once you file an application for reserving the unique name, and if your application is accepted, your name will be reserved up to 20 days for new companies. For existing companies which are planning to change their names, for them 60 days time period is given. Existing company to change its name, first it need to get special resolution from the members. For calling general meeting, they have to wait for 21 clear days. Do you remember? So 20 days is not enough for existing companies. So for existing companies which are planning to change their name, 60 days higher time period, and for the proposed companies 20 days. Extension of reservation, many students had a doubt in this point. Seema, day 0 name reserved. This name will be reserved up to day 20. For this you have to pay 1000. If you want extra 20 days, you have to pay another 1000 rupees. If you want extra 20 days, day 60, you have to pay 2000. One extension 1000, second extension requires extra fees 2000. That means here normal fees of 1000 for an additional 40 days. Additional 40 days means here 20 days, here 20 days. For additional 40 days, 1000 plus 2000, that is 3000 required. Getting my point, everyone? So extra 20 days required 1000, extra 40 days required 3000. So second time extension, this is first time extension, this is second time extension, the second extension required 2000 rupees. Getting my point? Next, cancellation of a name. If you incorporate a company, if you reserve the name by furnishing false information, like my name contains a word which is similar to the name of registered trademark. Now I should get NOC from the registered trademark owner. I didn't get it. I forged his signature. So doing this, I reserved my name. If ROC comes to know about this matter, ROC will cancel my name, and it may impose penalty on me up to 1 lakh rupees. Suppose company already incorporated, sir. Company already incorporated, sir. Then ROC, after giving opportunity of being heard, may direct the change of name within 3 months. That is nothing but rectification of name. Rectification of name. Section 16 is applicable. Or strike off, simply remove the name of the company. Or petition for winding up of the company. May file a petition with NCLT to liquidate the company, to wind up the company. Next one, situation clause in MOA. The importance of situation clause in MOA is CJI. CJI, what CJI stands for? Communication, jurisdiction, investigation. All the official communications with company are addressed to registered office. All the disputes are subject to jurisdiction where company's registered office is situated, and all inspection and investigation activities will be carried at registered office, because there we keep all statutory registers, records, books of accounts, and books and paper. So registered office should be established within 30 days of incorporation of the company. Within 30 days of incorporation of the company, every company should have a registered office. Same shall be communicated with a ROC. That is nothing but verification of registered office. Just a second. Yeah. So all the points I covered. Section 12, if you go with section 12 about IFSC, you will see a separate, you will see a special point. So object clause, ultra virus we completed. Next one, liability clause. Liability clause specifies the liability of the members. Company limited by the shares, liability is limited to the unpaid amount, and company limited by guarantee, liability extends to the deficit amount, that is assets minus liabilities if there is a negative figure. So assets minus liability, the deficit, winding up cost, that is liquidator remuneration, adjustment of rights among the contributories. For example, contributory 1 paid excess amount, contributory 2 should bring the amount so that contributory 1 settlement will be done. It's like partners adjustment, partners capitals adjustments at the after winding up, after dissolution of partnership firm, partner may bring additional amount to compensate the other partner. Example, I'll tell you. X and Y both are members. X contributed 1.5 lakh, Y contributed 0, total loss 1.5 lakh. Now imagine both X and Y had a equal liability. Now Y should bring 75,000, which will be paid to X, so that X will suffer a loss of 75,000, Y will suffer a loss of 75,000. So adjustment of rights among the contributories. List A, list B. List A members means, list A contributories means present contributories at the time of liquidation of company. Who the members of the company? They are list A contributories. List B means past contributories who transferred their shares or who ceased their membership within 1 year before liquidation. Within 1 year before liquidation. That means before liquidation, prior liquidation, go back 1 year. During this 1 year, whatever transfers happened, identify the transfers. If present members are not paying the money, then make past members to pay that amount. Past members means not for last 3-4 years. Past members means those who have transferred shares or whose membership got seized during the last 1 year before winding up. Next one. So on this, we had a exceptional question. Harmony Cultural Association Limited was incorporated on 1st April 2021 as a company limited by guarantee without share capital, with the object of promoting art, music, cultural activities. Maybe Section 8 company. See, this entire PDF, daily I'm preparing the questions. So mostly by 31st December, this document will be completed. Once completed, I'll post it. I'll upload in my drive. So the link is already, you can see in the description. Yesterday's video's description, you can see the link. Now after completion of this video also, I'll post that link. So this document will be ready by 31st December. So daily I'm preparing questions of 1 or 2 chapters. Once the document is ready, I'm coming for live. I'm coming to the live. Clear? Okay. So the memorandum of association stated that each member undertakes to contribute 50,000 to the assets of the company in the event of winding up. Mr. Amit Shah, one of the members, resigned from the company on 30th June 2023. Subsequently, due to continuous losses, company was ordered to be wound up by tribunal on 15th March 25. So if you observe, the gap between these two dates is more than 1 year. So now Amit Shah will never be a list A contributory. More than 1 year happened. At the time of winding up, company had outstanding debts of 18 lakhs, winding up expenses of 2 lakhs. So total 20. Disputes among contributories regarding adjustment of their rights. The liquidator demanded 50,000 from Amit Shah, contending that debts were partly incurred before his resignation. Mr. Amit argued since he was no longer a member, he cannot be made liable for the company debts. Okay. Separately, Bright Vision Private Limited, a company limited by shares, had unpaid share capital of 4 per share on 10,000 shares held by one of its members, Ms. Ria. Company went into liquidation on 1st January 2025. Whether Amit Shah can be held liable to contribute towards the debt of the company? Actual answer would be no, but here yes is there. So another printing error, another printing mistake. Let me correct it. This is not 2025, this is 2024. 15th March 2024. Then it will fall within 1 year. So small typing error. I'll do the corrections and I'll upload the same PDF in the description. Okay, don't worry, I'll update the link in the description. So here 15th March 2024, you take it. If it is after 1 year, his liability will comes to an end. So Mr. Amit Shah can be held liable as winding up occurred within 1 year of his ceasing to be a member. So 15th March 2024, go back 1 year. So go back 1 year means 16th March 2023. So he resigned. When he resigned, 30th June 2023 itself. 30th June 2023. Now it is falling within 1 year. If yes, specify the extent of liability. He is liable to the extent of 50,000 only. Limited liability, no unlimited liability. Limited by guarantee, limited to the extent of guarantee he given. Members are liable. Next one. What liabilities can be enforced against members of the company limited by the shares like Bright Vision Private Limited? Members are liable only to the extent of unpaid amount on the shares, that is 40,000 rupees. So 4 rupees unpaid value multiplied with 10,000 shares. Clear? Next, 7th question is about doctrine of constructive notice. So doctrine of constructive notice. Yeah. The doctrine of constructive notice established in Ernest and Nicholas states that anyone dealing with the company is presumed to have the knowledge of public documents such as MOA, AOA, whether registered with the ROC, which are registered with the ROC. Whether a person actually reads them or not, we will consider them as they are aware of MOA, AOA contents. And the exception to doctrine of constructive notice is doctrine of indoor management. In doctrine of indoor management, who will be protected? Company or outsiders? Company will be protected or outsiders? Outsiders will be protected. In constructive notice, company will be protected. In indoor management, outsiders are protected. And coming to the exceptions, company will be protected. Why? Because this doctrine is an exception to doctrine of constructive notice. Exceptions to indoor management means doctrine of constructive notice is applicable. Exception to exception means general rule is applicable. Generally exception means general rule not apply. But exception to exception means general rule is applicable. So we'll see. So doctrine of indoor management here. Outsiders dealing with the company can assume that internal procedures were properly followed, need not know about the internal issues. Stakeholders do not need to verify whether meetings have been held or not, whether resolutions have been passed or not. This doctrine protects outsiders by assuming internal proceedings align with the documents filed with ROC. This doctrine developed 150 years ago. This act, it acts as a safeguard against misusing constructive notice. But this doctrine had 3 exceptions. Remember, indoor management will not apply if in case of forgery, in case outsider could easily discover irregularities, that means that fellow is negligent. In case of negligence, in case of forgery, in case of doubt about existence of the agency, that means whether this fellow is director or not. If this fellow is a director, now act of a director, company is liable. If there is a doubt about existence of agency, or when there is a condition that when there is a precondition, it must be met before company can exercise certain powers like OR, SR. Right now, passing special resolution, one copy should be filed with ROC. It becomes a public document. Now for public documents, again doctrine of constructive notice is applicable. Clear? So the doctrine of indoor management contrasts with doctrine of constructive notice. Former protects outsiders against company actions, while later protects company from the outsiders. So based on constructive notice and indoor management, we will see an exceptional question. Okay, so tell me whether the speed is convenient. Speed of the lecture convenient. We will see question 7 meanwhile. Suryodaya Textiles Limited was incorporated on 1st April 2020 as a public company. As per its articles of association, board was authorized to borrow funds only after obtaining prior approval of shareholders by an ordinary resolution in a general meeting. On 10th July 2024, Mr. Ranjan, one of the directors executed a loan agreement with National Credit Bank for rupees 3 crores for working capital purposes. The loan documents were duly signed by the director and bore the company's common seal. Common seal is there. Documents were duly signed. However, no shareholders resolution approving the borrowing was passed. Later, the company defaulted in repayment and contended that loan was not binding. As the director had acted without internal approval and bank ought to have verified whether shareholders resolution had been passed by inspecting company records. Bank argued that it acted in good faith, relied on apparent authority of the director, could not be expected to verify internal management procedures of the company. Separately, it was found that in another transaction, company officer had forged signatures of other two directors to execute a guarantee deed in favor of the supplier. So here one is beyond the powers, not beyond the powers. Without members' approval, they borrowed the money and guarantee signature was also forged. Guarantor signature was also forged. So whether bank is deemed to have constructive notice of internal irregularities? No. Outsiders are not expected to know internal complaints of the company. Whether company is liable for repayment of loan taken by the director? Yes, company is liable. Doctrine of indoor management. Outsiders are protected. Company will not be protected. State doctrine applicable to protect the bank in this case. The applicable doctrine is doctrine of indoor management, that is Turkins rules. This is a silly question only. This is definitely a silly question. Don't expect this kind of question in the examination. Just a small question. Whether company would be liable in case of forged guarantee deed? The answer is no, because doctrine is not applicable to the forgeries. Doctrine is not applicable to the forgeries. Clear? So next question is about overriding effect of MOA AOA, section 6. We will see. Yeah, liability clause completed. Situation clause completed. All the clauses of MOA over. So articles of association. In these articles of association, these two are very, very important points. A, B, 2 points are very important. See, when can I have entrenchment clauses in MOA? When can I entrench AOA? The answer is entrenchment can be done at the time of formation of the company. No sir, I forgot. At the time of incorporation of company, I forgot. Then you can make an amendment to the AOA. If you are a private company, for entrenching your articles, consent of all members is required. That means unanimous resolution. If you are a public company, special resolution is enough. Special resolution is enough. And if you are making an alteration to AOA in order to entrench your AOA, once after getting this UR or SR, file a notice with the ROC about entrenchment provisions. Spice plus this is at the time of formation of company. Form MGT, that is for existing companies which are entrenching their articles. Next one, MOA AOA differences. I hope this point will not come in the examination, but ICA thumbline is very simple. Expect from unexpected areas. ICA tagline or thumbline, expect from unexpected areas. So just give one time reading. Content. MOA is a fundamental document. AOA contain internal regulations. MOA is purely for outsiders. AOA is for directors' powers, directors' duties. So internal governance. Supremacy, MOA overrides AOA, whereas AOA is just subordinate to the MOA. Scope, MOA defines the scope of company, what to do, what not to do. AOA deals with internal management. So actions beyond articles can be ratified, whereas actions beyond MOA cannot be ratified. Actions beyond MOA cannot be ratified. This is ultra-virus as to MOA. This is intra-virus. Intra-virus to the company can be ratified. Next, so section 6. On section 6 also I prepared one exceptional question. We will see. When there is a conflict between MOA, AOA, board resolution, special resolution, agreements executed by the company and Companies Act. Now which one will be the supreme? The answer is Act is supreme. Act overrides MOA, AOA, board resolution, special resolution, agreements entered into by the company. In case of inconsistency, in case of conflicting points, what happens? Act will apply. But here we had one example, we had one exception. Act overrides unless, this is an extra point, unless another section of the act expressly states otherwise. For example, if a section of the act declares something superior, follow that. Like for example, section 106, restriction on voting rights, you can take. Section 47 also you can take. It specifically exempts private companies. Section 106, restriction on voting rights also, if you see, subject to AOA, members voting rights can be waived off in case if they are holding shares with calls in arrears or if they are having some lawful dues to the company. Getting my point? Even section 51 also you take. Subject to AOA, dividends will be paid on face value. If AOA tells dividends should be paid on paid up value, follow your AOA. So some sections are giving supremacy to AOA. In that case, AOA can override Act. But remaining cases, Act overrides AOA. On this we will see exceptional question. Sunrise Foods Private Limited was incorporated on 1st April 2021 with an authorized share capital of 2 crores. The articles of association of the company contained a clause authorizing the board of directors to declare and pay dividend even out of capital reserves if the profits of company were insufficient. Super. Section 123, what it is telling, no dividend can be paid unless it comes from the profits. This rule cannot be changed by the provisions in the articles of association. If the articles attempt to do so, it will be void. Based on this point, paragraph you can see. During financial year 24-25, company incurred a net loss of 45 lakhs. Despite this, in a board meeting held on 15th May 2025, directors passed a board resolution declaring dividend of 10 per equity share, relying on the authority granted by the AOA. The dividend was paid to the shareholders on 30th May 2025. Relying on the authority granted by the AOA. Separately, AOA of the company also contained a clause stating that section 47 relating to the voting rights of the members shall not apply to the company. Section 47 exemption is there. Section 47 governs the voting power of the members but applies to private company only if their AOA allow it. In AOA, if they write different point, the different point is applicable. Statutory auditor objected to the dividend payment, stating it violates the provisions of the Companies Act 2013. However, directors argued that since AOA expressly permits such payment, resolution was validly passed. The dividend declaration is lawful. Let's see the questions. Whether provisions of Companies Act 2013 override AOA and board resolution of the company? Yes. Yes. For dividend payments, section 6, Act overrides MOA, AOA, board resolution. Whether dividend declared by Sunrise Foods Private Limited is valid? No. Because section 123 clearly telling that dividend can't be paid except out of profits. AOA cannot override Act. Whether provision in AOA excluding applicability of section 47 can prevail, since this is a private company, allowed. Yes, Act itself provides benefit to the private company subject to AOA. Then follow AOA only. Next, question 9 is about articles of association. About articles of association, that is binding effects of MOA, AOA. We'll see section 10 and then we'll come back to this. Yeah. MOA, AOA, binding effects. Here the point is, company incorporated in the year 1981 and I became member of the company in the year 2025. Am I bound by MOA or AOA? Why? Because I'm not in existence at the time of incorporation of company. Recently I became member. So I didn't sign MOA, I didn't sign AOA. Now my question is, am I bound by MOA and AOA or not? And the answer is yes. Yes, MOA, AOA once registered. Company responsible to members. All members are liable to the company. Members are also members not liable to each other. Even though you become a member subsequently, we make an assumption that upon becoming member, you are bound by the clauses of MOA and clauses of AOA. That's it. So based on this case laws, one exceptional topic, one exceptional question I designed. Let's see. Iron Shield Engineering Limited was incorporated on 1st April 2020 as a public company. Its articles of association contain following clauses. Article 15 stated that if any member becomes insolvent or bankrupt, his share shall be compulsorily transferred at a price determined by the board of directors. Yes, private company only, yeah? Public company, okay. AOA, public company or private company, members are bound to the company, company is bound to the members. Article 42 provided that directors may, with the approval of shareholders in general meeting, declare dividend payable to the members. And Article 60 stated that if a member intends to transfer his shares, he must first offer them to the existing directors, who shall purchase such shares equally at a fair value. Mr. Karan Malhotra, a shareholder, was declared bankrupt on 15th June 2024. His trustee claimed that shares should be sold in the open market at their true market value, contending that he was not bound by Article 15. See, whether you signed MOA, AOA or not a matter. Even if you are a transferee or even a person acquiring shares under transmission, you are bound by the provisions of MOA, AOA once you become a shareholder. Next, the assignee, the trustee of Karan Malhotra is wrong. In August 2024, the directors declared a dividend of 5 per share, but instead of paying cash, they proposed to issue debenture bonds to the shareholders based on a resolution passed in the general meeting. See, declared dividend should be paid only in cash. In kind not allowed. Separately, Mr. Rohit, another shareholder, expressed his intention to transfer his shares and duly informed to the board as per Article 60. However, directors refused to purchase these shares. Directors are bound to purchase these shares because Article 60 imposed an obligation on them. So whether trustee of Karan is bound by the compulsory transfer? Yes, trustee is bound, as AOA forms a contract between company and its members. Shares are taken subject to such conditions. Whether directors can validly issue debenture bonds instead of cash dividend? No. Declared dividend must be paid in cash only. Whether Mr. Rohit can enforce Article 60 against the directors? Yes. Member can enforce provisions of AOA against other members through a company. Members can enforce the provisions of AOA against other members, not directly but through the company. So Article 60 is imposing obligation on the directors to purchase the shares whenever existing members are intending to transfer the shares. Next one, question 10, it is about voluntary change of name. Another beautiful question, you will see. See, alteration of name clause of the company. Alteration of name of the company. So for this, what is the procedure? First, obtain special resolution. Next, a name change requires approval from CG, already power delegated to ROC. This is about, reserving unique name. Change of constitution doesn't need CG approval. Change of constitution, like private company converting into public company converting into private. So to add the word private or to delete the word private, CG approval is not required. Only for name change. If a public company wants to convert itself into private company, CG approval is required for change of constitution, not for change of name. Don't be confused. So change of constitution requires CG approval, but change of name due to change of constitution, CG approval is not required. Prohibition of name change. Defaulters. Sir, who are the defaulters, sir? Not filing annual returns, financial statements, not repaying or paying mature deposits, debentures, interest thereon, cannot change their name. Defaulters cannot change their name. Of course, name change is allowed after clearing all those defaults. When a company changes its name, ROC updates the register with new name and issue fresh certificate of incorporation. Section 16 is about rectification of name. Rectification of name arises in two cases. One is your name is similar to or identical to existing company name, or when there is an application by registered trademark owner that company name resembles with the registered trademark, and this fellow owner of registered trademark should file application with CG within how many years of company incorporation? 3 years of company incorporation, or 3 years of change of name by the existing company. So once started using the name which is similar to the trademark, the owner of the registered trademark should take action within 3 years. In 2 times, I think question came like this. After 5 years, owner of registered trademark filed an application with CG. And in the very recent attempt also, after 2 years, registered trademark owner filed an application with CG. So the first one is invalid, second one is valid, because second one it is within 3 years. First one it is after 5 years. Understood? So now central government will pass an order. Company should comply that order within 3 months by passing OR. Generally for alteration of MOA, SR is required. What type of resolution required? SR. But change of name, rectification of name, which is section 16, alteration of capital clause, which is 61, for these 2 cases OR is enough. For remaining cases, SR. For remaining cases, SR. 16, rectification of name. 61, alteration of capital. After a name change, company shall notify the ROC within 15 days. Submit the order of central government. ROC updates the certificate of incorporation and MOA. So within 15 days of OR, file documents with ROC. ROC will issue fresh certificate of incorporation. Suppose if company fails to comply with the direction given by the CG, CG gave you how many months time to comply with the CG's order? 3 months time. Within 3 months, if no action is taken by the company, then CG will allot a new name. ROC will update the register and issue a new certificate with the new name. Of course, if you want, you can change name under section 13 if you don't like the name allotted by the CG. So based on this, let's see one question. I think total 13 questions are from total 13 questions. 14 questions. 14 questions from incorporation chapter. Already 10 over, I think. Sorry, 9 over. 10th one. Brightline Infra Solutions Limited is a public limited company incorporated on 10th April 2021. Engaged in infrastructure consultancy services. Company has a paid up share capital of 5 crores, turnover of 42 crores for the financial year 23-24. No use. This paragraph of no use. Due to strategic shift towards renewable energy projects, Board of Directors in its meeting held on 5th January 2025 decided to change the company's name to Brightline Renewable Energy Limited. Okay. Accordingly, a special resolution has been passed by the shareholders on 25th January 2025. An application for name change was filed with the Registrar of Companies on 1st February 2025. However, ROC raised an objection stating that company has not filed annual returns and financial statements for the financial year ended 31st March 24, which was already due on 30th November 2024. Company had accepted fixed deposits of 1.2 crore. So here you can see default 1. Non-filing of annual returns, non-filing of financial statements. And company accepted fixed deposits from its members, out of which 30 lakhs matured on 31st December 24, but the same has not been repaid. Even interest was also not paid. Now company argues that since the delay is temporary, unrelated to the name change, ROC should allow the name alteration. So tell me, alteration of name, allowed or not allowed? Out of these 6 defaults, any one default is there. Financial statements, annual returns, deposits, interest on deposits, debentures, interest on debentures. Any one default is there. Company is not allowed to change its name. The solution is rectify the name and rectify the defects, go for name alteration. So whether company is eligible to change its name under Companies Act 2013, the answer is no. Whether application for name change filed on 1st February is valid? No, because application filed with ROC is invalid and liable to be rejected because of those defects. State the conditions under which company can proceed with change of name. Company must file all pending annual returns and financial statements, repay mature deposits along with interest before applying again for change of name. Clear? Next one is about rectification of name. There's also a concept over. Let's see. Blue Orbit Technologies Limited was incorporated on 12th August 2022 as a public limited company having its registered office in Hyderabad. Okay, first paragraph no use in examination also to waste your time. No, like this paragraphs will come to save your time in the examination hall. First you read the requirements. First go and read the requirements. After reading the requirements, come back and read from first onwards so that you can identify the points which are required for question or answers. Question and answers. What are the requirements? You can understand only those points you will highlight. Getting it? So promoters of the company are Mr. Ravi Kumar and Ms. Neha Sharma, who are also directors of the company. The statutory audit for financial year 23-24 is conducted by RK and Co Chartered Accountants. In January 25, when company was incorporated, 2022. January 25, Blue Orbit Solutions Private Limited, an existing company incorporated in 2015, represented before RD that the name of Blue Orbit Technology Limited is too resembling with the name and causing confusion among the clients and vendors. Simultaneously, Blue Orbit registered trademark under Trademark Act 1999 applied to RD on 20th January 25, claiming infringement of registered trademark. 20th January 2025. Is it within 3 years from 12th August 2022? Yes. 12th August 2022, add 3 years. 12th August 2025, 23, 24, 25. So here when he is filing application, 20th January 25, application is valid. After examination, RD issued a direction on 10th February 25 requiring Blue Orbit Technologies Limited to rectify its name. Now from this date onwards, the order will be valid for 3 months. That means within 3 months, change the name or else RD will assign a new name. However, company neither passed the resolution or complied with the direction till 15th May stating internal management disputes. Whether provisions of section 16 are applicable? Yes. Rectification of name, section 16 is applicable. Whether application made by the trademark proprietor is valid? Yes, it is within 3 years only. Whether the inaction of company after receipt of direction is legally permissible? No. Comply the order within 3 months. What action can be taken by CG and ROC in case of default? CG may allot a new name. ROC shall issue a fresh certificate of incorporation, which company must use thereafter. Still 4 more questions, and those 4 more questions are from exceptional points. I'll show you section 20, 21 like that. We'll see. I think last question already marathon. Revision is done with the last question. 14th question. Yeah, 14th question. Green Access Solutions OPC Private Limited was incorporated on 10th June 2023 with its registered office at Vijayawada, Andhra Pradesh. The company is engaged in IT consulting services and has a paid up share capital of 50 lakhs. Sole member and director of the company is Mr. Harish Rao. Introductory paragraph. On 1st August 24, company changed its name to Green Access Digital Solutions OPC Private Limited pursuant to approval of the registrar. During financial year 24-25, company operated from its registered office and branch office opened on 1st January 25 at Guntur, my hometown. Okay. During an inspection conducted by the registrar of companies on 15th April 2025, the following observations were made. What are the observations? Branch office did not display company's name and registered office address outside the premises. Question on section 12. Okay. I think, yeah, this is the point. I'm sorry. So far I read the introductory paragraph only. Remaining points I'll read it after section 12. After section 12. First I'll read section 12 and then I'll read the content. I'll read the requirements of the question. A company shall maintain a registered office after incorporation within how many days? Within 30 days. For IFSC companies, 60 days time limit is given. IFSC companies, the time limit is of 60 days. Next one. Yeah. Company shall verify its registered office within 30 days of incorporation. That means file a verification of registered office with ROC within 30 days. Should be signed by professional also. Director and professional will sign this document INC 22. For IFSC companies, what is the time limit? 60 days. So this would be an exceptional point in this entire section. Name board. On the name board, affix name, address outside of its office, including branch office, in legible letters both in English and local language. Common seal optional. Official documents, that is invoices, vouchers, everything. Company name, registered office address, SIN, contact details like such as telephone, fax, email, website. So total seven things should be printed on name, on all official publications. 7 points to be noted: name, SIN, registered office address, telephone number, next one mail ID, website address, fax number if any, shall be printed on all official business letters, bill heads, letter papers, notices, official publications. Instruments, the company name shall be printed on negotiable instruments. In case you change the name, new name and old name should appear for next 2 years. That means last 2 years if you have changed any name, along with new name, old name shall also be disclosed. The words OPC must be mentioned in the brackets under the name of company wherever it appears. Next one, notice of any change in the registered office shall be given to the ROC within 30 days of change after incorporation of the company. For shifting of registered office, generally special resolution is required. But if it is within the city, board resolution is enough. Within the local limits, municipality limits, board resolution is enough. But change of city, change of state, change of ROC jurisdiction, remaining cases SR is compulsory. So change of registered office outside the jurisdiction. For this, let me give you one equation. Change of registered office, shifting of registered office. Generally, 3 cases. First one is within same city, town, village. Within same city, town, village. Change in city, town, village, but no change in state. No change in state. Last one is change in state. Change in state. But here, problem comes with respect to Tamil Nadu and Maharashtra. In Tamil Nadu, we had 2 ROCs. Other states, generally 1 ROC for each state. Northeastern states, Mizoram, Manipur, Arunachal Pradesh, Nagaland, all these, some northeastern states, some 5 to 6 states had only single ROC. Because business activities, those areas are predominantly less due to geographical locations. Now, for Tamil Nadu, Maharashtra and for other states, so what is the procedure, or what is the whose approvals to be taken is the question. So here, simple board resolution plus ROC filing is enough for shifting registered office within the city, town, village, within the same city, town, village. Next one, coming to the change in state, coming to the change in city, town, village, no change in state and no change in ROC. No change in ROC. For this, the equation is board resolution plus special resolution plus ROC filing. Coming to Tamil Nadu, Maharashtra, ROC changes may happen. ROC changes in ROC, like Mumbai to Pune, Pune to Mumbai, Chennai to Coimbatore, Coimbatore to Chennai ROC jurisdictions. In that case, board resolution plus special resolution plus RD approval plus ROC filing. ROC filing. And in case of change in state, board resolution plus special resolution plus creditors approval. Creditors approval plus CG approval, but power already delegated to RD plus ROC filing. So if you observe, in each and every stage, a new approval is getting added. Like here you can see SR, here you can see RD, here you can see creditors. In each and every stage, additional approvals you can see. Clear? So remember these equations, that's enough. Remember these equations, and little bit time limits are also required. Little bit time limits you need to remember. The time limits, let me write here itself. RD will give approval within 30 days of filing application. Within 30 days. ROC filing should be done within 60 days. ROC filing should be done within 60 days from the date of RD approval. And here, let me change the color. Here, CG approval, or that is RD, will dispose the application within 60 days of filing application, within 60 days. And ROC filing should be done within 30 days of RD's order. Simply interchange the time limits, ma. Interchange the time limits, that's it. Case 4 will be done. And important, interesting, exceptional point is these 3 cases you take, these 3 cases within the city, changes in city, town, village, these 3 cases, MOA alteration not at all required. Alteration of MOA not required, not required. But last case you take, MOA alteration is required. Alteration of MOA is required. So here you need to attach one extra document, that is copy of minutes, and another document is list of creditors, last case. So with this, section 12 next shifting of registered office, everything is done. Everything is done. Just take a screenshot of it. Just take a screenshot of it. That's it. Next one, we'll see question 14. Yeah, during an inspection conducted by the registrar of companies on 15th April 2025, following observations were made. Branch office did not display company name and registered office address outside the premises. This is definitely default only. Company letterheads include and invoices did not mention SIN. This is another default, because all official publications require name, registered office, SIN, contact details. The word OPC was not printed below the company's name on business letters. Again default 3. Company was issuing promissory notes to the vendors without printing its name on such instruments. This is also default only. Further, only new name was displayed at offices and on all letterheads without mentioning the old name, even though change happened within the last 2 years. This is also default only. Whether the provisions of section 12 subsection 3 relating to labeling of companies are applicable to the above case. So section 12 subsection 3 is applicable. Ignore this kind of questions, don't worry. So I'll modify it. I'll modify this document and I'll upload in the Google Drive. Ignore this, too much about section numbers, question will not come. Identify the non-compliances committed by Green Access Digital Solutions Private Limited. Non-compliances: failed to display its name, address at branch office, failed to mention SIN, failed to print name on promissory notes, failed to include OPC below its name. Whether company is required to mention its old name along with the new name. If yes, how long? 2 years. 2 years. Once name has been changed, for the next 2 years, along with new name, in brackets mention old name also. So we are left with 2 questions. So these 2 questions are relating to the service of documents only. Service of documents and authentication of documents. I hope we are almost at the end of the chapter only. This point just now I completed. Alteration of object clause, for alteration of object clause, special resolution is required. And if you are a company having more than 200 members, postal ballot is required. And I forgot to add this point, here, in all these cases, SR, wherever SR is required, that special resolution shall be passed through postal ballot. That point I'll stress it in the management and administration chapter. If you are a company having less than 200 members, yes sir, special resolution is not required. Sorry. Special resolution is required, but postal ballot is not required. Getting it? Members up to 200, postal ballot is not required. Members exceeding 200, postal ballot is pakka. For alteration of object clause, for alteration of situation clause. So yes, company that raised money from the public through a prospectus can still use unutilized funds for new objects, provided a special resolution has been passed via postal ballot. So the notice must contain financial details, changes details, impact assessment, additional information. Published in 2 newspapers. One is in English and the other one is in vernacular newspaper. Vernacular language. That means vernacular language means local language where company's register office is situated. And having a wide circulation. The paper should have wide circulation. Also place it on company's website. This is an exceptional point, ma. This is an exceptional point. Dissenting shareholders will not continue with the company. Promoters or controlling shareholders must give an exit opportunity to the dissenting shareholders. And ROC to certify the alteration. So ROC register the alteration of the company's objects and certify it within 30 days of filing application. So within 30 days of SR, file it with ROC. Once documents received by ROC, ROC will issue certificate within next 30 days. So 30, 30. 130 for filing with ROC, another 30 is for confirmation by ROC. Alteration to be noted in every copy. Every copy of MOA shall reflect any alterations made. If any copy is issued without noting the alteration, company and its officers will be liable for a penalty of 1000 per copy. Next one, alteration of AOA. Alteration of AOA includes conversion of the companies. Alteration of AOA includes conversion of the companies, private to public, public to private. For that, simply if you insert section 2 clause 68, that is restrictions, limits, prohibits, it becomes private company. Public to private requires insertion, whereas private to public, removal of this clause. For this, special resolution is required. Next one, alteration converting public to private company requires CG approval within 60 days from the date of passing special resolution. Approval is filed using e-form number RD1 with the regional director along with the fees and shall be accompanied by the following documents. What are the documents? Draft MOA AOA, copy of minutes, copy of board resolution or power of attorney, declaration by the KMP. About compliance, declaration of compliance by the KMP. Filings with ROC should be done within 15 days, and any alteration in the articles once registered is valid as if originally included in the articles. So that means if you don't register your altered AOA, then that altered AOA is null and void. Your original AOA will be valid. Only after registration alteration AOA gets validity. This is also important point. Once you make any alteration to MOA AOA, make a note of that alteration, or else 1000 rupee per copy is a penalty to the officer in default as well as company. Next one, upon request by a member, company must send copies of the following documents within 7 days of request on payment of fees. That is MOA AOA agreement resolution. See, today you are making request of some documents, return request. Along with the return request, you have to pay some amount, sufficient amount. In that case, within 7 days, it is the duty of company to serve those documents to the requested member. Within 7 days, the requested documents should be given to the member. Request alone is not sufficient. Along with request, payment of fees is also required. In 2 or 3 cases, I seen the question. That question is, there is a request, but there is no deposit of money. In that case, is company bound to deliver MOA AOA to the requested members? Answer is no. Along with request, sufficient payment of money is also required. Next one, commencement of the business. See, if you are a company with the share capital and if you are a company registered on or after 2nd November 2018, if any company satisfy these two conditions, with the share capital on or after 2nd November 2018, date of incorporation, it should not commence business. Business should not be commenced. Borrowing power should not be exercised until company satisfied two conditions. What are the two conditions? Declaration of paid up value. Director shall file a declaration within 180 days of incorporation stating that subscribers to MOA have paid agreed value of the shares they subscribed to. Second one, company should file verification of registered office with ROC within 30 days of incorporation. One is 30 days, verification of registered office, time limit 30 days. Declaration of paid up value, the time limit is 180 days. Upon compliance of these two conditions, company is allowed to exercise borrowing powers, company is allowed to commence its business operations. Clear? If no declaration is filed, then ROC may remove the name. If delay in filing happened, 50,000 penalty to the company, 1,000 per day up to 1 lakh penalty for the officers who are in default. Non-filing leads to removal of name. Delay in filing attracts penalty. Clear? Two conditions. What are the two conditions? File INC 20A within 180 days of incorporation. About subscribers of the MOA deposited agreed amounts and verification of registered office has been done. And of course, this declaration shall be verified by practicing professional. Special entities like, business, banking business, stock exchanges business, next one insurance business. So prior approval from the sectorial regulators should also be obtained, and the same shall be attached along with this declaration. Next one, 19th one, last attempt only, this point was tested for 2 marks. Last attempt, September 25 attempt, this point was tested for 2 marks. One MCQ came. So most probably next attempt it won't come, but we don't know, because May 25 and September 25 NFRA question was repeated. Duties of NFRA. So that's why you see the point. Subsidiary company is not allowed to hold shares of holding company, and holding company should not allot shares to the subsidiary company. Beautiful logic is there. This is a marathon, so I can't tell that logic here. For the time being, circulation of the funds from holding to subsidiary, subsidiary to holding, circulation of funds should not be done. That's what the reason. Subsidiary is not allowed to acquire shares of holding company. But we had 3 exceptions. One is legal representative, other one is trustee, and the last one is before becoming subsidiary. First 2 cases voting rights allowed. Last case no voting right. No voting right. Why? Because before becoming subsidiary, if it had acquired any shares of holding company, after it becomes subsidiary, after that it became a subsidiary. Now it will be under the control of holding company. Whereas as a legal representative, as a trustee, it works for beneficiary. It works for beneficiary. That's why those 2 cases voting rights allowed. Last case, it is already under the influence of holding company, voting right not allowed. Almost 1.5 hour completed. Oh god. We'll do one thing. I'll complete this chapter in this session. Evening session, evening 8 to 9, 9:30. Since general clause sect is a small chapter, foreign company is also a small topic. I'll cover those 2 topics, general clauses, foreign company, in evening session. Actually daily 1 session only, but yesterday due to some banking works, I couldn't take up the session. So that's why today morning I took this session. Clear? Fine. Service of the documents, documents can be served by registered post, speed post, courier service, leaving at registered office or electronic mode. For demat securities, record of beneficial owners can be served electronically by the depository to the company. Why? For giving a notice of AGM, company will collect who the beneficiaries of the company, who the members of the company gets the data from the depository. So depository will transmit every data through electronic mode, electronically. And documents can be served on ROC or any member by post, registered post, speed post, courier, or electronic mode if prescribed. For example, you see INC 22, next one INC 20A, next one some INC 4, INC 18. All these are electronic mode filings only. All these form filings will be done through electronic mode only. So if prescribed, electronic mode, or else post, registered post, speed post, courier is enough. Member can request for documents through a specific mode. Request alone is not enough, See, request alone is not enough. They need to pay sufficient fees to meet these postal charges, courier charges, are nothing but postal and handling charges. Simply postal and handling charges, you have to pay sufficient fees. Nidhi company. On this point, I framed exceptional question. Serving documents to the members holding more than 1000 or 1% of the paid up share capital or service by public notice to the other shareholders in local newspapers and notice board of the notice board of the company. In case any member is holding greater than 1000 rupees face value of securities or greater than 1% of the paid up share capital, any one condition satisfied, to this member serve notice via post, registered post, speed post. That means individual notice is required. Individual notice should be given. Other persons, simply small members, for them individual notice not required. Give an advertisement in local newspaper and display it in the notice board of the company. That's it. We'll see the question. Question 12. Sri Lakshmi Nidhi Limited is a Nidhi company incorporated on 15th July 2018, having its registered office in Guntur, Andhra Pradesh. The company has a paid up share capital of 150 crores divided into 15 lakh equity shares of 10 each and 1200 members as on 31st March 2025. Okay. If you remember, e-voting is applicable in case company is having more than 1000 members, 1000. But Nidhi company is exempted from the provision. E-vote is not applicable to Nidhi companies. The board of directors consists of Mr. Ramesh, Miss Suma. The statutory audit for financial year 24-25 is conducted by Mrs. Rao and Co. Chartered Accountants. Company convened its annual general meeting and company convened its AGM scheduled for 30th September 25. On 20th September 25, company sent AGM notices. 21 days before only notice must be given. But okay. By speed post to 300 members holding shares of face value of 10,000. What I told you, face value, 1000 limit I told you. Paid up share capital percentage time limit 1%. More than this, individual notice. Up to this, notice board notice is enough. Notice in the notice board of the company is enough. For remaining members, by publishing a public notice in a local newspaper circulated in Guntur district and displaying the same on the notice board of the Nidhi company. Further, a show cause notice dated 10th October 2025 was sent by ROC to the company's MD via email using email address earlier provided by the company. Certain members argued that AGM notice was not properly served, while managing director claimed electronic service by ROC is invalid. Who told? Prescribed mode allowed. If he requests for specific mode, then specific mode will be followed. 1 second, yeah. Whether the mode of service of AGM notice adopted by Nidhi company is valid? Yes, service is valid as notices are sent to eligible members individually and to the remaining members through public notice and notice board display. Whether service of show cause notice by the ROC through email is legally valid? Yes, service through electronic transmission is valid as per section 20. At what time shall AGM notice sent by speed post deemed to have been served? 48 hours. Via post, it takes 48 hours for transmission. If it is electronic mode, instant transfer. The last question is with respect to section 21 and 22. We will see it. Section 21 documents to be signed by the company. It's enough if it is authenticated by KMP or officer employee authorized by the board. So KMP, who comes under KMP? CEO, CFO, MD, CS, manager, officers one level below the directors. Observe here, the condition is only one level below the directors. Second one, they must be in full-time employment. And third one, designated by the board. 3 points you have to remember. Who can be KMP or who can be appointed as KMP? Officers one level below the directors who are in full-time employment designated by the board as a KMP, then that fellow becomes KMP. 2 levels below the directors, not allowed. 1 level below the directors but not full-time employment, part-time employee. Now also not a KMP. KMP, he should be full-time employee designated by the board and he should be a person only just 1 level below the directors. Next one, section 22, last one section 22. Bills of exchange, hundis, promissory notes is deemed to be made, accepted, drawn or endorsed on behalf of company if done in the name of company or on behalf of the or on account of the company by any person with authority, maybe express authority or implied authority. So how that authority comes, that power of authority, simply power of attorney document should be signed by the 2 directors of the company or 1 director and 1 CS if CS is there. If common seal is there, affix common seal. If there is no common seal, no need to affix. But it should be signed by 2 directors or 1 director and 1 CS. Then only the deed will be valid. The documents will be valid. So based on this, we'll see last exceptional question. Astro Agro Equipments Limited is a public limited company incorporated on 10th May 2020, engaged in manufacture of agricultural machinery. The company has a paid up share capital of 6 crores, turnover of 55 crores, no use at all. The whole board of directors consists Mr. Sanjay Verma, who is a MD, that means KMP. Next one, Ms. Pooja Iyer, whole-time director, KMP. Mr. Arjun Rao, independent director, not KMP. The company has also appointed Mr. Kiran Mehta as its company secretary, KMP. On 15 June 2025, company purchased raw materials worth 40 lakhs from Greenfield Steels Private Limited to settle the payment of Mr. Sanjay Verma without a specific board resolution, but in the ordinary course of business. You see, ordinary course of business. That means it comes within the implied authority. Separately, on 1st July 2025, Astra Agro Equipment Limited decided to execute a mortgage deed for securing a term loan of 3 crores from National Bank Limited. Company did not have a common seal. The deed was executed by one director alone without any power of attorney or authorization by the two directors. Now this will not come within the implied authority. Express authority is required for this. Two directors or one director plus one company secretary signature is compulsory. Later, disputes arose regarding validity of the bills of exchange. Whether bill of exchange accepted by MD is valid? Yes, because it is in the ordinary course of business covered under implied authority. Whether execution of mortgage deed is valid? No. Formal deeds must be executed through a properly authorized attorney. That attorney gets power through a document which must have a common seal, if common seal is there. If no common seal, two directors should sign the document, or one director and one CS if CS is there should then only the deed will be valid. That means deed signed by the attorney will be valid. Attorney should get power from a document which should be signed by two directors of the company or one director and one CS, or else attorney will not have any power. That means representative will not have any power. What corrective steps should be taken? What corrective steps should the company take to validly execute such deeds in the future? So written authority signed by two directors or a director and CS to execute deeds as attorney. Clear? So with this, I completed incorporation of company revision and exceptional topics, exceptional questions discussion also. Time is time over. So we'll do one thing. Foreign company and General Clauses Act. Both are small topics. Foreign Companies Act, compulsory one descriptive question or 3 MCQs will come. 5 marks weightage chapter, 5 to 6 marks. And General Clauses Act is having a weightage of 14 marks. So these two small topics we will cover in evening lecture, that is mostly from 8 p.m. onwards. Clear? Okay, fine. I hope you understood this exceptional questions. Okay. So that's it. We'll meet in the evening session.